We have a really strong panel. We're going to bring the energy, right, Russell?
You got it.
Yeah. All right, let me first introduce Stacy Bogert. She's with the SEC, Associate Director in the Enforcement Division, where she has served for over 15 years. Thanks so much for joining us. Our moderator is Russell Capone, a partner at Cooley in New York. That's Russell right there to my left. A former AUSA in the Southern District of New York, where he served as Chief Counsel to the U.S. Attorney. In the middle is Terence Healy, a partner at Hughes, Hubbard, and Reed in Washington, D.C. And previously, Terence was Senior Assistant Chief Litigation Counsel for the SEC's Division of Enforcement. At the far end is Jeff Kern, a partner at Sheppard Mullin in New York. Jeff was former Senior Regional Counsel in FINRA's Department of Enforcement and also Senior Trial Counsel in the New York Stock Exchange's Enforcement Division. Welcome, Jeff. Finally, very pleased to welcome Lorin Reisner. He's a partner at Paul Weiss in New York. He previously served as Chief of the Criminal Division of the U.S. Attorney's Office for the Southern District and also as the Deputy Director of the SEC's Enforcement Division. Russell?
All right, thanks, Bruce. Thanks to all of you for sticking it out till the end, 45 minutes till cocktails. This may not be quite as fun, but we'll try to make it interesting. Subject of our panel, Subject of our panel is SEC-related criminal investigations and prosecutions. So that can take a few forms. For example, parallel investigations between the SEC and DOJ, a criminal prosecution accompanied by an SEC case, or even an SEC investigation in which it's not clear whether there is a U.S. Attorney's Office in the background covertly, or could be one day. So each of those sort of different scenarios present different challenges, and that's what we will talk through today from both the SEC perspective and the defense perspective. So let's dive in. I'll turn to Stacy first. Stacy, can you tell us give us a rundown of the timeline and progress of an SEC investigation if there's also a parallel DOJ proceeding? How is that different than if it's just an SEC investigation?
Let me start off with the disclaimer, your last one of the day, that all of my comments today are my own and do not necessarily represent the views of the SEC or the commissioners. So to answer your...
Remember to do that right at the start. Usually people are 5 minutes downstream before they recall to say that.
Got to keep it lively. To your question, how it turns out that we may be working on a case where there's a parallel investigation, that can really vary. Sometimes we're working on an investigation of our own and the conduct's particularly egregious, and we may make a referral to a criminal agency. And Joe Sansone and George Canellis talked earlier about some of the circumstances where that might be the case. There are also cases where we get referrals from the criminal prosecutors themselves. That's probably a little less frequent than circumstances where we make a referral, or the third scenario, which is conduct that's so egregious that there are multiple agencies that are interested, maybe not just the SEC and criminal authorities, but also maybe a host of other federal and state civil and criminal agencies. So it can be a variety of different players involved conducting parallel investigations. To answer your question about the process, I think the process really does depend upon the case. The thing I would pass on to you all as defense counsel, if there are parallel investigations as defense counsel, don't assume that the case with the SEC is going to be the same necessarily as other cases you may previously had. In part, that's because there are potentially other agencies involved. In part, every case, has its own facts and circumstances. So, procedurally that, of course, can look a little different. Witnesses participating in proffers or joint proffers, where in another situation it might be SEC testimony. But, importantly, the timing may also look a little bit different. So, and this can be true for various reasons related to the type of conduct that's going to result in a parallel investigation. So, when you have cases where the conduct is egregious enough that it merits and involves parallel investigations, there may be concerns about ongoing harm, concerns about the dissipation of assets, or the flight risk. of potential individual defendants, and that all can have an impact on the timing of the investigation. So what you might see in a SEC-only investigation could be a little different in terms of timing, in terms of process, when there's other agencies involved. So that might be the timing of when a case is actually brought. It could be whether or not there's a Wells notice. So what I would suggest to you is, if there is an issue that is important to you or your client, I recommend being proactive about bringing it up. Don't assume that because in a prior case, maybe the SEC reached out and proactively was talking about settlement. Don't assume that may happen, in a case where there's a parallel investigation. It really just depends.
And do you if there's a DOJ parallel investigation from the SEC's perspective, is that advantageous? Are there disadvantages to that? Is it frustrating to have to deal with another agency?
What was Melissa's line last year? I don't find anything frustrating. No, I mean, I don't. When we have parallel investigations, I don't view it as either advantageous or disadvantageous, because we're going to have our investigation no matter what. And we'll be taking investigative steps no matter what, regardless of whether the criminal authorities are involved or not. I mean, different agencies bring different things to the table. Criminal investigators have different tools. We have different tools. I do think one way it is beneficial to investors in protecting the market is in the event that both the criminal authorities and the SEC bring a case. I think the fact that the SEC has different charges it can bring, which may or may not involve scienter. It can reach a larger group of defendants than criminal authorities may end up charging. Criminal authorities are often charging individuals and not necessarily corporations. We may bring charges against the gatekeeper or who permitted the scheme to happen, or we may proceed against a supervisor who failed to appropriately supervise the wrongdoer, and that's other aspects of addressing the misconduct that aren't going to be part of a criminal case. Similarly, there's going to also be differences in terms of the relief that each agency brings to the table. So obviously, criminal authorities get a lot of attention to misconduct, and they have the ability to, arrest someone and seek imprisonment and forfeiture and restitution. We have complementary remedies, asset freezes and other emergency relief, disgorgement, industry bars, and conduct-based injunctions. So I don't talk about advantage or disadvantage, but I will say that when both agencies are there, when you've got conduct that's that bad, I really do think it is to the benefit of, the victims and protecting the markets, because it really can bring the full panoply of relief to the table.
And one more question before we go to the defense perspective, which is, are there ever situations in which the department or U.S. Attorney's Office is involved but more in the background, and the SEC is taking the lead and is investigating more overtly with a sort of criminal element covertly and sort of not yet surfaced?
So pretty much every permutation you can think of probably does happen. There are cases where, we're out there communicating directly with someone, and criminal authorities may have interest but haven't communicated directly with them. It really varies, I think. At the end of the day, whether or not the criminal authorities have serviced or not, that's a decision that they make on their own, and we are working independently.
So turning to Lorin, for company clients, what are the approaches or considerations at the outset that you have to consider when there's an SEC investigation? In particular, if there's not yet an overt criminal matter, but there could be. What are you thinking through, and how are you advising your clients?
Well, look, anytime I'm handling an SEC investigation that I know has a potential criminal element, I'm very mindful of it, because something that, an investigation that poses a significant risk with, very substantial consequences could turn into something that's truly existential for the company. So you've got to keep your eye on the ball and the potential for the criminal authorities to swoop in and get involved. What does that mean from a practical matter? Well, following on something that Stacy said, look, when you're, for example, structuring your presentations to the SEC staff, it could be that the SEC has an area of interest that's relatively specific, and where that there's a risk that other elements of the a client's business or other issues may present interesting issues for the criminal authorities that don't happen to be the focus of the SEC's investigation, either because they don't involve the securities laws or otherwise. You can sometimes navigate the situation to manage the risk of the potential interest by criminal authorities. So that's, you got to be mindful of that risk and manage the matter as best you can to control the risk. Obviously, when you're representing individuals, you have a whole host of additional issues to keep in mind with respect to the potential involvement of criminal authorities that I think others on the panel may address.
And how about if the matter, the sort of potential criminal liability will clearly be sort of individual liability. So let's say it's an insider trading matter, unlikely to be enforcement ramifications for the company. How is that going to change your approach to dealing with either SEC or DOJ?
Look, probably not a ton. I mean, look, when you're representing a public company in connection with an SEC investigation, your posture is almost inevitably going to be a cooperative posture. And the cooperation is going to consist thematically of the same issues that are always presented. Learning the facts, developing the facts, and presenting the facts to the staff on the topics that they're interested in. Whether or not there's a potential for individuals to be involved or individuals not to be exposed to liability. Obviously, as you develop facts, if it turns out that the company is a victim of individual misconduct, whether it's insider trading, whether it's a rogue employee or otherwise, that presents a set of considerations that will often lead you to, in describing the facts to the staff, demonstrating clearly that the company, that the conduct at issue was not sanctioned and done without the involvement or participation or approval of the company. But, as Joe Friday used to say on Dragnet, it's basically just the facts. When you're in a cooperative posture, you're developing the facts, learning the facts, figuring out a way to communicate them clearly to the staff, and presenting them, and let the chips fall.
Jeff, how about from your perspective? What are the things you're thinking about at the outset of a parallel proceeding?
Well, look, channeling what Lorin said, no one wants to go to jail, right? And so the consequences are enormous. And so on a practical level, one of the first things I do, even though I'm a former prosecutor and I do have a criminal defense practice, I was not an AUSA. So I'm going to get one of my partners who was an AUSA involved. Second, I'm going to work with that partner and we're going to do an internal investigation and see what the potential criminal exposure is. And human nature being what it is, oftentimes clients, and I tend to represent individuals and smaller companies, so they're sort of coterminous with one another, but people don't readily countenance that they may have broken the law or that they face these consequences. But you've got to do your own fact finding, and you've got to assess what the potential liability is, because I think that's going to dictate not only how you deal with the DOJ, but with the SEC. And then, look, you can't assume you understand the working relationship between the DOJ and the SEC, because as Stacy said, there are many permutations of those arrangements. So you've got to do what you can, use your connections, your network, read the tea leaves, and try to understand what that relationship is, because I think that's going to guide how you might approach things.
You mentioned that you represent a lot of individuals. Terence, sticking with that topic, how is the calculus different if you're representing an individual in a parallel SEC DOJ investigation where your access to information is going to be a lot more limited than if you're representing the company?
Right. As Lorin said, if you're representing on the company side, the process is sort of the same. If you think somebody has potential concerns about Fifth Amendment, you get them a lawyer, they can deal with it. I think what's interesting about the kind of work we all do, when you're representing the individual, especially the kind of people who found public companies or create a hedge fund that they grow to have significant AUM, it's a certain kind of personality. These are people with drive and high risk tolerance and this kind of alpha male approach. I say alpha male because they all, ones getting in trouble, seem to be men. And they have really high executive function, and they are not used to not being in control. So of course they all want to testify, they all want to go in, they all want to explain to the government, they want to talk directly to the judge. So if we know there's a parallel criminal investigation, obviously that is a very different kind of Fifth Amendment analysis. Do we testify, do we not testify? And sort of a lot of different issues, but since this is about parallel investigations, can you use, if you know a criminal case is coming, there's a SD&Y involved, and really once investigations start, they always seem to lead to charges. Can you use the civil side to leverage more information you would have otherwise? The holy grail of the parallel investigation is, can you get testimony from the cooperating witnesses in the SEC case or in some other form? So it's a very different analysis, and it's one that with the kind of individuals, not all of them, a lot of the kind of people have that belief, this unshaken belief in their own ability to control situations and convince people of things, because maybe they could walk into a room with very sophisticated asset managers and get them to allocate tens of millions, hundreds of millions of dollars, or they had the audacity a lot of times to take some company and make it public, or have lead a SPAC. They're never satisfied with counseling patients, and a lot of times it's almost can become like a daily conversation you have with people, and they need someone to be angry at, and they can't call up Stacy or the 5 people at the SD&Y and yell at them. So oftentimes and their wife is sick of talking to them. So oftentimes we are the person who gets to feel those types of conversations.
Yeah, just to follow up on what Terence said, look, I think the toughest decision for the subject of an investigation or defendant in a criminal investigation with their lawyer to make is whether to testify at trial. I think the second hardest decision is whether or not to testify during an SEC investigation when you know that a criminal investigation may be very likely or in the wings. But sometimes you're in a position where, just as Terence said, you have a client who very much wants to testify and is dedicated to arguing his case or describing his case during SEC testimony. Sometimes you make a judgment that that's really the best strategy. Not only is it what the client wants to do, but it's the best strategy to get to the outcome that you desire in the SEC investigation, to have the client testify, and you're prepared to absorb the risk of negative consequences with respect to a criminal investigation. Other times, you make a judgment that it's not wise for the client to testify during the SEC investigation, and you can't convince the client that that's the right path to pursue, and the client testifies anyway. One interesting quick war story, I had a matter where we represented an individual who was the CEO of a public company in a case that I think any objective observer would think that criminal investigation was also a possibility. And this former CEO testified, provided SEC testimony. At the time that he testified, there was no overt criminal investigation. And 2 weeks after his testimony, there was a grand jury subpoena received. Of course, we were very curious to know whether or not the criminal authorities were in the wings at the time that his SEC testimony took place. We were also very curious to know whether the SEC knew at the time that they took his testimony that the criminal authorities were involved and were likely to swoop in with a grand jury subpoena afterwards. In fact, in subsequent proceedings, we sought discovery on that issue that the SEC resisted. So I don't think we really know for sure what the SEC knew. We have some idea of it, but these are not easy decisions to make.
Although that's on you and your client.
Well, I mean, there is that one case where the court found that the DOJ being in the shadows and directing an SEC investigation violated the Fifth Amendment rights of the defendant.
Yeah, and Stacy, the issue in this case was less focused on SEC potential misconduct and more focused on potential misconduct by the prosecutors in how they conducted the investigation and their level of communication or lack of communication to us and our client.
Is there ever, if there's an overt DOJ investigation, will it ever be the right decision to testify in front of the SEC? I mean, it may be the case that in most such scenarios, there will be no SEC testimony until the DOJ investigation is over, but have any of you been in that type of circumstance where you've had to deal with testimony in the middle of an overt DOJ investigation?
Yeah, just make one quick comment. And from the kind of people we're talking about, the SEC investigation, they take the Fifth and lose the case. You're talking about not just their, getting a bar. You're talking about significant financial resources and penalties. So it's not an easy decision. It's easy for us to say, there's only one case that matters, and when you're being the subject of a parallel proceeding. Obviously, if you don't win the criminal case, who cares? So that has to be the paramount concern. But there's a lot at stake, so it's not an easy decision when you're the person involved, especially when there's a reason why, other than lawyers are the worst witnesses, as we all know. The second worst witness by category is probably CEOs, because they're so used to sycophantic behavior and always being the guy who comes in first. They think they can walk in and charm the investigators or who's ever taking the examination.
But I think the short answer is the default decision, obviously, if there are overt parallel investigations, is that most individuals who are the subject or target of a criminal investigation are highly likely to take the Fifth in connection with requested SEC testimony.
Let's talk about when is the right time to make sure that executives or other employees have their own counsel. So Lorin, you're representing the company in an SEC investigation where there's potential for criminal ramifications, which is what we've been discussing today. What are the factors you're considering and who to recommend individual counsel for? And does that ever change as the investigation proceeds?
Yeah, well look, if there's an individual officer or employee who has a significant risk of personal exposure, either SEC exposure or DOJ exposure, we're almost always, if not always, going to recommend that individual retain their own counsel. Sometimes we'll seek input from Stacy or her colleagues, and we'll ask SEC staff or staff from the U.S. Attorney's Office, whether they have a view on whether a particular person should have their own counsel. And it really varies, I think, staff member by staff member, the extent to which you'll get feedback on that. There will be some members of the SEC staff who will say, yeah, we think it's a good idea for that person to have their own counsel. Others will say, hey, that's up to you and up to the individual whether or not they retain their own counsel. My experience, and Russell, I don't know what your experience at the U.S. Attorney's Office was on this. Prosecutors, AOSAs are probably more willing to share their views on those issues than SEC staff attorneys. And AUSAs, I think, tend to be a little bit more assertive in the view that individuals should have their own counsel. So there are instances where you might not think that an individual needs their own counsel. I think it's rare to get an SEC staff member reach out to you on their own and initiate the suggestion that somebody obtain their own counsel. That's not rare, or not particularly rare. In the criminal context, you will get calls from AUSAs saying this person should get their own counsel.
And we don't use the terms target or subject.
course.
What you may hear people asking about are conflicts. That may be something that you hear us raising, early on, potential conflicts between someone who's representing the company or individuals. That's the way it may come out.
That's a nicer way to ask the question, actually.
I've had a couple of recent experiences where the SEC staff attorney have come right out of the chute and they say, basically telling me that I need to get them other counsel. That wasn't well taken by my side. But look, you have to consider what they're saying, that they're presumably coming from a good place. And it's obviously, a warning that, you may have issues that you didn't think of and you need to get on your horse and figure it out. But when that happened, I did all those things, and the intent was, yes, we're gonna talk to the individual about getting them counsel, but sort of a catch-22, because in order to have that conversation, you have to kind of debrief them and explain, and in doing so, you might be getting information from them that if they had counsel, they may not wanted to share with you. So I think in those situations, I will go ahead and do the debriefing and have the conversation, but I also want to be careful.
Changing topics, Terence, if you're dealing with an SEC investigation, working with the staff, you're concerned that there may be a criminal investigation, but you don't know. Do you ever just pick up the phone and ask nicely of the SEC attorney whether there's a U.S. Attorney's Office involved?
Yeah, I mean, they'll never answer the question. Sometimes if they have bad poker players, you can kind of judge by their discomfort when the question is asked. Also, talking to company counsel, even if the company counsel is a little hostile, and other sources of information, counsel for other witnesses, who are represented, obviously defense, Stacy, don't listen to this part. Defense lawyers are always sharing information about, what are you seeing, even if their clients are not fully aligned. But, that decision that Lorin spoke about earlier, like you said, the second biggest decision you have to make, do you testify during the investigation, or do you allow the client to testify? Obviously, if we know there is going to be criminal activity, that changes that analysis greatly. I would say, in the olden days, like 10 years ago, you could look at a case, comes into the door, and some cases, maybe an SEC case here, definitely some problems, but you could tell a civil case from the kind of case where you'd say, whew, this clearly has the potential to be charged criminally. Now, to me at least, I think that line is blurred quite significantly, where cases where, okay, there's an SEC case here, now suddenly the SDNY is working on an indictment. So it's harder, in my view, to really evaluate the cases that clearly have criminal exposure and those that do not.
So just to follow up on that, I agree with what Terence said. In one of the earlier panels, I sort of smiled. It was on the accounting fraud and disclosure panel. I think one of the panelists, it might have been the SEC representative, said something like, more cases are being brought and charges being asserted in judgmental areas. And I thought to myself, judgmental areas. And I guess that's okay for an SEC case to be brought in a judgmental area, but criminal cases shouldn't be brought in judgmental areas. When I was at the SEC, I was comfortable supporting matters that I thought were gray areas because there were good policy reasons to pursue those cases at that time. But as chief of the criminal division, as a prosecutor, you don't pursue cases in gray areas. The criminal law should be black and white. And I think Terence is right. I think that if there is a trend the trend is to be a little bit more aggressive, and prosecutors seeing things in shades of black where maybe they should be seeing shades of gray.
Turning to the subject of sort of the respective progression of civil SEC and criminal matters, and for example, stays. Stacy, how often is it the case that either the SEC is asked to sort of stand or slow down pending the criminal proceeding, or to, if there's a parallel prosecution and SEC action, to stay it, to consent to a stay, and what goes into that decision?
So are you talking about a stay in terms of once a case has been filed?
Yep.
So I think you'll frequently see the criminal authorities seeking a stay once a case has been filed, and the SEC typically doesn't take a position. We neither object nor consent to the stay. They're frequently granted, although there are a few judges who don't grant the stays. In either case, from the SEC's point of view, we're prepared to go forward. We don't know, you don't know what judge you're going to get. You don't know whether there's going to be a stay or not. We make our own charging decisions and are prepared to move forward with our case, whether there's a stay or not.
And how about before you get to that point, if you're investigating in parallels, are there ever circumstances in which you have to consider sort of slowing down your activity and deferring to DOJ, or no?
Here again, fact and circumstances, the timing can vary. I think what you see most frequently is a parallel criminal case being announced at the same time the SEC case is filed. But there are situations where we might file before or after criminal authorities if they have a parallel investigation. It really depends. If, for example, there might be a need for an emergency asset freeze, there might be a need for, which might cause us to go first. You might see criminal authorities filing first because of a concern about a flight risk. So it really does vary. But it varies, but what you see most commonly is filing it simultaneously.
Can I ask Stacy a follow-up question?
Please.
You can always ask.
So Stacy, given the choice between a single proffer session together with the criminal authorities that's attended by both AUSAs and members of the SEC staff, and a separate proffer session that would be attended only by the SEC staff, do you have a preference?
I think I would turn that question back around to you. I can't imagine defense counsel would really want to do separate sessions if there's a parallel investigation. I would think you guys, even more than anything, would be asking to do them together. I think, from our point of view, we're just looking to gather the evidence, and whether that happens via testimony, via joint proffer, or via individual proffer, we're prepared to move forward.
Okay.
Terence, do you have any views on that subject of joint interviews?
If I could push back a bit on my friend Stacy, we have these, we call them, I think it's a farce to call a lot of these investigations parallel. They're joint. You have cases where the SEC and DOJ do dozens upon dozens of interviews together. In the interviews, DOJ always tells the SEC staff, don't take any notes, only the agent takes the notes. Then the case gets charged, and then you find that the SEC didn't take any testimony under oath. So while the SEC has tools that are different than DOJ, in these circumstances where they elect not to use those tools simply so they don't create any potential evidence will be inconvenient for DOJ, they're really not acting independently. And you've had cases where the STOI has a slot with the grand jury, and there's a date, and they have to get there, and what would be a very long investigation by the SEC is now truncated to so they can file the same day. So that's where I think, in terms of the SEC always, the idea that the SEC will file a parallel case with DOJ, and then when DOJ immediately comes in to stay it, takes no position on it, I think really undercuts the independence with which the SEC is acting. If they filed the case with the allegations, they should want to move forward, and they should take a position about whether their own case gets stayed or not.
Let me back up and start with the part where you, as you were a former SEC staffer. We are not structuring our investigations to further a criminal proceeding. I think you talked about that it raises an eyebrow that there are lots of joint proffers and no testimony happens, but we talked a few minutes ago on this panel about how many people would counsel their client not to testify. So, I think it's no surprise that when people know there's a parallel criminal proceeding, there isn't testimony, and a lot of things are happening through the format of interview or joint proffer. So I don't know that there's anything nefarious to be inferred from what the point you've raised.
Yeah, I would just say you have large public companies. There's all sorts of witnesses who do not have any criminal exposure. There'd be witnesses for the SEC, witnesses for the prosecution. So, in my experience, when there's a large investigation with dozens upon dozens of interviews, yet not a single testimony or oath was taken, it raises question in my mind, at least, as to why is the SEC electing not to use the tools it has, and what extent is that influenced by the Justice Department not wanting inconvenient things
That's called
reported.
Coordination. That's allowed under Squishy and Stringer. I mean, there's nothing that obligates the SEC to take testimony. You may not like it, I may not like it, but I think the law is pretty clear on that. As long as the SEC is pursuing its own, independent regulatory and enforcement objectives, it can conduct the investigation however it wants, and it can coordinate with the criminal authorities however it wants. And I think that's, I agree. I know it can be frustrating, but I think as a legal matter, that's permitted coordination.
I can't remember whether it was Terence or Jeff who earlier referenced, now sort of back to the scenario where you have an SEC action but no criminal prosecution. There may be an investigation in the background, but one of you referenced potentially using the SEC action to get discovery that might work to your advantage in any potential criminal matter that comes down the road. So I'll open that up to anyone who wants to comment on that.
I think it was Terry.
Yeah, I have to. You look at all the case law about a stay of the civil case, almost without fail, you can tell whether the stay gets granted or not granted based upon whether the defendant asked for a stay, almost always denied, or whether DOJ asked for the stay, virtually always granted. Not in front of Judge Rakoff, and I do know Sonny Balwani wasn't involved in that case, but the request for stay there was denied. If you can get civil discovery and depositions and move forward, it's an opportunity for a defendant in a criminal case. That kind of risk taker who has to be willing to testify himself or herself if it comes to that. There is obviously a significant, far broader discovery available under Rule 26 than there is in the corresponding federal criminal Rule 16. Judge Rakoff has said it's bewildering, that was his word, that a criminal defendant should not be entitled to an equal amount of discovery of a civil defendant. As I said, as we all have experienced, when DOJ wants to stay is almost always granted. And really, it just, I think if you look at like the Second Circuit standard in Louis Vuitton, all those factors really should be looking at what is the interest of the defendant, not the convenience of the prosecution, and not having to worry about there being evidence created in a parallel proceeding. And if the interest of justice is in the truth, I don't see how more evidence and more light being shown on that could not be in the interest of justice. I also note, and I've seen increasingly, we're talking about kind of C-suite executives who get separated from their company, thrown out, and very little access to information. There's always arbitration provisions in these separation agreements, and these circumstances, it seems more often than not, there's disputes about who's breaching the separation agreement. The company that make the payments is supposed to make. The former executive was supposed to do things that he or she is not doing. And arbitration moves very quickly. It's the one thing where discovery can really get ahead of what's going on in a criminal case, even though criminal cases move quickly. And arbitration panels can make decisions that are different than what the courts do. Had a case where the arbitration panel ruled that the well-known law firm that did the internal investigation effectuated a complete waiver of the investigation, including its own files. And this was contrary to what a federal district court judge had ruled in the same case. So that is arbitration is always something that also can be another option for a criminal defendant to level the playing field, Lorin. Get a little more information.
Yeah, and there's also that middle ground that some judges in the Southern District are adopting these days of not imposing an entire stay of discovery of the filed SEC action, but issuing a protective order based on witnesses that the government identifies as essential witnesses or cooperating witnesses. You may end up in the same place because although you're entitled to some discovery, you're not really getting discovery from the witnesses who are most important. So the field is not level, Terence.
We talked about witness interviews being done in tandem, but one aspect of these investigations that is not necessarily done in tandem is sort of document discovery and subpoenas, right? Your DOJ is going to proceed via grand jury subpoena, SEC very differently. Lorin, sort of what are the challenges in sort of dealing with sort of two masters asking you for having all sorts of different requests, asking for different types of documents, custodians, and how do you navigate both investigations if they're going on in parallel?
Be as responsive as possible to both sources of the request for information. I mean, that sounds like a silly answer, but it's the right answer. It's interesting. Sometimes where you have two different requests, one is a very broad request, one is a narrower request, and to make things easier for yourself, you just provide the same production to both requesters. There are some in the DOJ and the SEC that will thank you for that and say, thank you for sending all that stuff we didn't ask for. There are others who will say, why did you send us all that stuff we didn't ask for? Or, why are you burying us in all this mess? Give us the stuff, or focus on the stuff that we asked you for. You don't know how somebody's going to react. You try to have as much dialogue in advance so you're minimizing surprises and improving the level of communication, but really trying to both be responsive and demonstrate that you're being responsive are essentially your objectives when responding to subpoenas or information requests.
All right, we have under 2 minutes. There's one other topic I wanted to get to. Lorin, I'll stick with you for this one. We've talked about investigations and sort of the charging stage, but how about resolutions? What are the challenges in trying to resolve an SEC and criminal matter sort of on the same track? And are you ever, for example, attempting to leverage a potential SEC resolution in attempting to advocate for the department to go away?
Well, we could have a whole separate panel on that question, but I think that the best response is obviously under the principles of federal prosecution of business organizations, one of the factors that DOJ is required or directed to consider in deciding whether or not to bring charges is the adequacy of a regulatory resolution. So certainly, Russell, you're thinking when you have parallel investigations whether there is an opportunity to resolve an SEC matter with the type of relief and scope that might be persuasive to the prosecutors that they have no need to pursue a criminal matter. And sometimes, in the best cases, you'll get a signal from the prosecutors early enough that they will view an ACC resolution as satisfactory and won't pursue criminal charges if such a resolution can be attained.
All right, well, thank you to the panelists. Thanks to everyone for sticking with us.
All right.